From Miami Law, I'm Annette Uguez, and this is The Explainer.
This is a big deal. The court has, over the last 20 or so years, heard cases in which it has tried to think about presidential removal authority. But this case, unlike either of those cases, squarely puts the question of the case called Humphrey's executor versus the United States. Also, ironically, or not so ironically, who knows, involving the Federal Trade Commission and President Franklin Roosevelt's attempt to remove a commissioner during his term in office.
Welcome to Season 15 of the Miami Law Explainer, the legal affairs podcast where University of Miami law experts lend context and historical relevance to today's headlines. Last week, the Supreme Court allowed the president to fire a member of the Federal Trade Commission using the emergency docket, part of a trend that has ballooned over the last several years. On this week's show, constitutional law expert Charlton Copeland susses out presidential authority. Let's go to our executive producer, Catherine Skip, with the interview.
Good morning, Charlton.
Good morning.
Hey, great to see you.
Great to see you, too. Thanks for having me.
Nice to be seen. We're recording this on Wednesday, October 1st, hours after the Supreme Court ruled a commissioner of the Board of Governors of the Federal Reserve could not be fired until they hear the case. This is in contrast to other rulings where they have allowed the president to fire members of other boards, including a member of the FTC. What do these decisions mean for the future of other independent agencies?
Well, thanks so much for having me. We've been trying to do this for a little while, and this is one of the most appropriate subjects and the most appropriate time, so we couldn't have picked a better time. So I want to focus a little bit on the FTC, because the Federal Trade Commission case has been, like the case with respect to Commissioner Cook, has been set for oral argument in the Supreme Court. The Federal Trade Commission case in December of the new term. And in that case, the answer to your question lies. That is, the court has articulated as the questions to be answered in December as should a nearly century-old precedent that restrained presidential removal authority from so-called independent agencies, should it be overruled? That has been flatly put on the table. In addition to the question of whether or not the statutory constraints that are inside the organic statute that created the Federal Trade Commission, whether they are in fact unconstitutional as a violation of separation of powers, particularly the president's Article 2 power. And then secondly or thirdly, depending on how you think about it, the court has raised a question of the district court's remedial authority. I won't talk much about that, but this is a big deal. The court has, over the last 20 or so years, heard cases in which it has tried to think about presidential removal authority. But this case, unlike either of those cases, squarely puts the question of the case called Humphrey's executor versus the United States. Also, ironically, or not so ironically, who knows, involving the Federal Trade Commission and President Franklin Roosevelt's attempt to remove a commissioner during his term in office. Whether that nearly century-old precedent is going to be overruled. That essentially said, Congress has the authority to create agencies that are not completely controlled by presidential authority. Now, I say not completely controlled because the president appoints and has the capacity to remove for a cause, but cannot remove, if it's not a for cause decision.
So Roosevelt was not successful?
Roosevelt was not successful, right? In an earlier case, a case that was decided 9 years earlier, there was a successful challenge in a case called Myers versus the United States. There was a successful challenge to a congressional attempt to constrain the president's ability to remove a postmaster general. And there, the court said, you can't remove. I'm sorry, the court said any attempt to constrain the president's removal authority is an unconstitutional constraint on the president's ability to control the executive branch, right? The Chief Justice at the time is also former president, was a former president, but he wrote saying, look, the president may not get his pick, but burdening the president with a person with whom the president no longer wants to work, right, who has lost the president's confidence, cripples the executive. And so the court said, no, Congress can't constrain the president. Subsequently, in Humphreys, the court looked at the Federal Trade Commission, looked at its authority, looked at the way in which it undertook its functions, and says these functions are primarily quasi-legislative, quasi-judicial. They do not partake of the executive's authority. And so Congress was well within its rights to say the executive should not have control over the Federal Trade Commission and thereby could not remove the Federal Trade Commission's members.
So you talked a little about cases over the last 15 to 20 years involving Sarbanes-Oxley and Dodd-Frank have already expanded the president's authority to fire executive officials, correct?
Now, the court...
Executive agency officials,
The court would say no. The court would say, we did not expand presidential removal authority. What we refused to do was expand exceptions to the president's removal authority. That is to say, they would have argued that what Congress did in enacting Sarbanes-Oxley and creating what the court called this double layer of for-cause removal. And if we have a minute, I'll try to explain that. So in Sarbanes-Oxley, the controversy ultimately was, right, this was the Enron controversy. Controversy was the public accounting organizations that got in bed with Enron and helped them cook their books, essentially. Sarbanes-Oxley was enacted to try to prevent that. And one of the mechanisms for that was to create the Public Company Accounting Oversight Board that would oversee that relationship. The members of that board would be appointed by members of the Securities and Exchange Commission. Members of that board could not be removed by members of the Securities and Exchange Commission except for cause. Except the members of the Securities and Exchange Commission can't be removed by the president but for cause. And so the court says this is a double layer of for cause removal. Right. Chief Justice Roberts, writing for the court, said, no, this undermines the president's capacity to control the executive. The Public Company Accounting Oversight Board is going to have a large control over the U.S. economy, public companies, and to that extent, the president's electoral possibilities, the president's reputation will be vulnerable to the actions of members of a commission over which he has little to no control. And so essentially the court says unconstitutional. Similarly, after the 07, 08 crash, right? We came back with Dodd-Frank. We created the Consumer Financial Protection Bureau, which was unlike the PCAOB, unlike the Federal Trade Commission, unlike the SEC, a single member headed agency who had a fixed term. The court says, we've never given a fixed term to a single-headed agency. And in that case, the court basically looked to the FTC and other multi-member agencies as the models and said, those are the kinds of agencies over which we constrain the president's removal authority. They're bipartisan, they're multi-membered, they have staggered terms. And so the Public Company Accounting Oversight Board and the Consumer Financial Protection Bureau were seen as outliers, right? Attempts by Congress to push their constraining authority even further. And the court said, no, we're not going to expand Humphreys. But now we are actually in a confrontation with Humphreys, the likes of which we haven't seen. Now, one of the narratives that has been developed, that I think was developed in those earlier cases, is this narrative of presidential vulnerability. This sense that the president has to come before the country and get reelected. The president is the only official who is subject to the national electorate. And here the president is saddled with officials who are making big and important, largely financial decisions over whom the president does not have control, right? And so there's this narrative that the president is hamstrung. There's narrative that the president is vulnerable. And it seems to me that it's that narrative that in some sense has picked up steam, that now creates this sense that, well, maybe even Humphreys is too far. And so now we've got that confrontation.
Can you talk a little about the potential confrontation with the Federal Reserve? Like, what are the real-world consequences if the Fed loses its independence from the president?
So this is interesting, right? Because again, the Fed is a multi-member board, as it were. But the Fed, and even the court has suggested in some sense, that the Fed is different, right? That the Fed and its independence is crucial to the functioning of economic markets, to the functioning of America's global prestige as an economic player and as a trusted economic player, right? All of those things go into to this, I suspect. Now, again, there are going to be others who say, well, that's no different than fill in the blank, the Federal Trade Commission or the Securities and Exchange Commission. But I think to the extent that the court has seen the Fed as different, you might end up with a set of decisions in which the court, and I don't want to say this because I think that it's hard, I'd be hard-pressed to suggest that the court will overrule Humphrey's executor. What I suspect the court will do is to make a decision based on the facts. And one of those arguments on the facts is to say the FTC of 2025 looks more like an executive actor partaking in executive authority than does the FTC of 1935. And so the facts on the ground have changed.
Right.
Humphreys continues to exist in principle, but the facts, it's not the law that's changed, it's the facts that have changed.
Right.
And so Congress has, right, over the years, is the argument, given the FTC all of these new and transformative authorities and has now turned it into the kind of agency that the president has to control. If that were the decision, then it seems to me the Fed might be spared, right? That is to say that the court might articulate a different set of facts around the Fed's role that might nevertheless justify constraining presidential removal authority. I don't see the court going as hard, but I do think the oral argument in December will give us some clues to that.
To what's going to
happen in January, right? That is to say, if you see an oral argument in December that is based on how transformative the changes in the Ford's in the FTC's exercise of authority have been since Humphreys, then I think that sets us up for a decision that's really going to be about the facts. That's going to be able to say we didn't overrule Humphreys. Congress has transformed Humphreys, and I think that this is a very Chief Justice Roberts move. That is to say, if you look at the Voting Rights Act, what Chief Justice Roberts says in the Voting Rights Act case in Shelby, he says, look, the facts on the ground have changed. South Carolina went for Obama. Blacks vote at higher numbers than other populations in lots of southern states, right? The law isn't changing, but the facts on the ground are changing. Court says the same thing in NFIB versus Sebelius with respect to the Medicaid decision. The court says the Affordable Care Act transformed Medicaid into, in some sense, a new Medicaid, right? And so where the line is for the Roberts Court between the old version of something and the new version of something is sort of hard to identify, at least for me. But that Chief Justice Roberts is very comfortable making those on the ground sort of factual decisions about radical transformation in national policy and programs for the purposes of reaching some decision is a move that he has made often. And it wouldn't surprise me if he made that move. And again, that would signal to me that the Fed is probably going to be treated differently.
Are we looking, is there a bridge too far or is there never a bridge too far? Or are we looking at a future where every 4 years the entire leadership of all of these boards change over at the whim of the president, of the executive.
I think that may be where we're headed. I don't know, right? If the next president is a Democrat, the next president is going to be confused. Is going to be charged with unilateral disarmament if that president attempts to go back to the old regime, right? If that president says, you know what, despite the cases, I'm going to appoint 3 Democrats and 2 Republicans or independents or whatever the practice has been, I suspect members of the president's party are not going to be happy with that president.
Right.
And so I'd be hard pressed to think that we are going to find our way back to the state of bipartisan agreement around
anything,
who should serve on these multi-member boards.
Right.
Now, the other scenario might be, right? And again, this is another thing that the Chief Justice has done. Now, he hasn't always done it with the support of the other justices who tend to vote with him. Is what he will also do sometimes is to basically rewrite the statute. So he'll say, okay, so if the president can't remove X, then the agency can't engage in these activities. So you might see a kind of writing down of the FTC's authority to say, okay, well, unless the president can remove members of the Federal Trade Commission at will, then the Federal Trade Commission can't exercise these powers that we take to be executive. Strike them all out. You guys get to decide how that looks. And so
you only get to decide what we have for lunch on Wednesday. No other things. no other decisions.
Right? And so now that is not a decision, again, that I think he's generally been joined by fellow judicial conservatives on, right? And in fact, when he writes in that mode, the liberals tend to agree that, okay, well, we don't have to tear the whole house down. We can tear only parts of it down. And so I think it's less likely that Chief Justice Roberts has the support to do that.
Right.
And so what I think this is going to be is, FTC and he's already hinted at this. Even in earlier opinions, he suggested that maybe from a factual basis, Humphrey's got the scope of the FTC's powers wrong. So I think that's probably where we're going.
Right.
Yeah.
Anything else we should be watching for?
Oh my goodness, everything.
Everything, I know. The Daily Assault.
I think that this is, it's funny, right? I say this as a person who sometimes teaches Con Law 1, but who's not teaching Con Law 1 to our 1Ls in the spring. And as I prepared for this, all I could think was, man, at least I'm teaching administrative law. I can think about these things in administrative law, but I'd love to be thinking about these things in Con Law 1. Yeah. That is not me signing up for Con Law 1, but it is to say that we are going to
The walls have ears.
Exactly. We are going to have an amazing spring. And so this is
amazing in a good way. Or?
I don't know that the statement attributed to the Chinese, may you live in interesting times, was always a wish for good luck. And so to that extent.
Well, thanks so much for coming in.
It is always a pleasure being with you.
Always fun having you.
Thank you.
All right. See you around.
Thanks for joining us for another episode of the Miami Law Explainer. If you enjoy our show, leave us a 5-star review with your podcast provider and ask your friends to subscribe. Our show is engineered and edited by Christopher Alzadi with theme music composed by Rady Kim from the Frost School of Music. I'm your host, Annette Uguez.